Well, with the elections now just 6 weeks away, we've seen some political parties getting involved with the situation inside some companies. In some cases, in recent years, political parties have been involved in internal disputes between workers and their employers. At least one party has what they call a labour desk, where workers can go and complain about their employers. Imraan Mahomed is the Director of Employment Law at CDH. Imraan, good afternoon to you. So when we see a dispute between workers and employers, and workers will look anywhere for help, can they go to a political party? Can a party get involved in that kind of dispute?
Good afternoon, Stephen. A very good question, but perhaps if I can reel it back. So if we look at the dispensation that we currently have in relation to employment governance in South Africa, the system is no doubt a very sophisticated one. And these were all carefully crafted at the dawn of democracy. So employment legislation in the mid-1990s was one of the very first pieces of legislation that was crafted in order to meet the democratic era. Now, what would not have been envisaged at the time is that political parties in a democratic South Africa would become embroiled in workplace affairs. But as you correctly say, in the last couple of years, and we see it of late as well, politicians do get involved in employment disputes and in workplace affairs rather frequently.
I mean,
so the question. Sorry, go for it, Steve.
No. You were talking.
No, so I wanted to make the point that in relation to my own experience, I've represented employers in cases where members of, believe it or not, the National Assembly, and in one instance, a member of a provincial legislature would rock up and demand an audience with the employer. And that gives rise, as you can imagine, to a ripple effect in relation to where does an employer stand and where do workers stand. So your initial comment is that workers do look for different avenues, but does our law allow for workers to do so, particularly where we have such carefully crafted pieces of legislation? So all of this starts to unravel as it gets into court, and that's where we are currently, and we get in a sense over the last period of time with regards to where the courts stand in relation to such questions, which is particularly helpful so that employers are able to manage their affairs, politicians know where they stand in relation to workplace issues, and particularly trade unions, which are meant to be the voice of workers, are able to know where they sit in workplace-related issues.
I'm going to come to trade unions in just a moment. I would imagine that there's no way that you could stop a politician, say in the middle of a strike or some kind of public workplace dispute, from making a comment one way or another, whether they favour the worker or whether they favour the employer. You couldn't stop them from speaking publicly. At what point then is it wrong for them or illegal for them to get involved? I mean, can they demand entry into the workplace? Now, that's private property. I imagine that could be quite difficult for a politician to do.
Yeah. So you correctly say, or you correctly make the point that politicians are entitled to have a view in relation to any issue. So expressing a view in relation to a particular issue is not unlawful. It becomes unlawful if there's incitement to violence or there's incitement to unlawful conduct in the workplace. That would make the conduct unlawful. Our law and the Labour Appeal Court has now come to accept that political parties, as a general principle, are permitted to assist in employment matters, but only in an advisory capacity. So the limitation is an advisory capacity. They can't get actively involved in workplace issues because that's, in reality, the domain of trade unions. And that's why the legislation specifically empowers trade unions, and with a constitutional right, to act on behalf of their members. And that's where the power dynamic should sit and must sit in relation to workplace affairs.
Unions are supposed to be the people who do this, right? I mean, it's not supposed to be politicians. I mean, and that's why often, I mean, you look at unions and politics and you know, where the line between them is very complicated. But, I mean, surely unions should be the first place that workers go to. I know sometimes unions fail or sometimes unions aren't interested, but it really should be unions, not politicians.
Yeah. It's a point you make fabulously well. I mean, I can't put it any better than the way you have. But what it does is that it goes to a point that I made a bit earlier. It unravels a system of law that was carefully designed in order for workplace issues to be dealt with by unions that represent the interests of their members. So what we've got is an unraveling in relation to representation where union members particularly take a position that unions are not acting in their best interests, or alternatively, they're not through the processes being able to achieve what they seek to achieve. So what do they then do? They go off to a trade union, they move away from the trade union and look to a political party to advance their interests. Your opening comment was with reference to the labor desk of the EFF. That's a classic example. The ANC Youth League is another example. So I've come across across my desk quite often the ANC Youth League making demands of employers in relation to workplace issues. So it's a slippery slope, but it's one that our courts have now come to recognize, and one in relation to it, at least there's a framework for employers and trade unions and for political parties to know precisely where each plays in relation to workplace issues. The advance in relation to the courts, and something that we should be thankful for, is that the courts accept that there's the constitutional right to protest and assemble and assert those rights. But there's also the regulation in relation to workplace issues that are specifically determined under our employment laws, and that tension must be dealt with in a perfect balance. So the rights of employees are perfectly protected, and so is the right of workers, and the ability for an employer to conduct business, which is a constitutional right as well at the end of the day. So that tension and finding the equilibrium has played out in the courts over the last couple of years, and fortunately the Labour Appeal Court has now come to set that balance, so that where these issues do arise, employers are in a position to say, is a politician in these particular circumstances acting within their mandate or acting lawfully in making certain demands? And if they're not, what is the right of the employer or management in that instance to protect its own interests? So the developments or the advance in our law over the last couple of years has been rather positive. And a very recent judgment of the Labour Appeal Court, which was handed down a couple of months ago, was a matter that arose out of a dispute between the ANC Youth League and a business out in Umhlanga. And what had happened, just very briefly, is that the Youth League had organized a protest to the doors of that particular workplace. And the question in that particular matter was whether or not the organization by the Youth League ultimately related to a workplace issue, or was a workplace issue one of various issues that the union was dealing with in relation to that particular employer, which gave rise to management seeking an interdict against the union. And there was good principles set out of that judgment in relation to where trade unions sit, where political parties sit, and management in relation to protecting their interests qua particular disputes with their own employees. So the principle is political parties are entitled to become involved in an advisory capacity. They certainly can't assert rights of employees within a workplace and assert workplace rights, because they've got no rights of audience before tribunals such as the CCMA, the Labour Court, and the like, which are the tribunals and the courts that have been set up to deal with workplace issues. So hopefully with time, as we get past this election, and as our democracy continues to mature, hopefully in years to come, we'll see less of an advance of political parties in the workplace. I'm hopeful that would happen, and a better empowerment of trade unions to assert the interests of their members, because that's what our system is actually designed for. It's not for political parties to become involved in workplace affairs, because it does become a slippery slope.
Sure. Imraan, sorry to interrupt. I mean, we have a situation now where we're in elections. People are talking about politics everywhere. Can an employer tell their employees to stop talking about politics in the tea room around the water cooler? I mean, sometimes politics can lead to disputes. Can you say to a worker, you're not allowed to wear your blue overall on one day and your red overall on the next because we're in an election season? It can pose some difficult questions.
Yes, it does. Fortunately, a matter of that sort has found its way to the Constitutional Court in relation to the dawning of political regalia in the workplace. So a lot's happened over the last 30 years. And our laws been able to grapple, and employment laws or employment lawyers have had to grapple with a lot of these social issues, social political issues. It ultimately goes down to rules and policies within a workplace, how they're meant to be maintained, because ultimately it is a workplace, and a workplace is not a political, is not a place for political campaigning, but casual conversations can be had, but within limitation, not to give rise to issues that would cause conflict within the workplace or create tension amongst the workforce. Because if that were to occur, that would give rise to disciplinary matters and issues that should ultimately not be within the workplace.
Thank you very much indeed. Really do appreciate the time. Imraan Mahomed is Director in Employment Law Practice at CDH.